love to introduce Marlon. If you can join us with can you grace us with your presence, Marlon? Most of you probably know Marlon is. If you have not seen Marlon on either Cape Talk or on social media, I think you might be living under a rock. But Marlon has been in business for many, many years, as we can see, for over 26 years. And sometimes I wonder how he is getting to everything that he does, because is he duplicating himself into six? Is he really, really good at what he does? Is it the combination of the two? And welcome. Nice to have you online with us today. And we look forward to seeing what you have to offer for us. So, Charisse, yeah, if we can just start with saying today, I do not think we all, as the legal industry or the property industry, always appreciate the work that goes into the legislative changes. So, Marlon has played a huge role in helping some legislative change take place. But today we're going to speak about one specific topic. But before I do that, Marlon is not just a cool attorney and a nice guy, but also quite funny. So for those of you who don't follow his Facebook posts, make sure to do so for some little bit of lightness and making fun or a little bit of light about some serious matters. Just a funny post that Marlon actually posted at one stage. But for those of you who don't follow his posts on all the various property management groups, he's got quite the sense of humor. So Marlon, why is this judgment important? Tell us, why do property practitioners that typically don't really pay attention to legislative changes or to case law, why must they pay attention to this one, and what makes this one special?
Absolutely. Firstly, just thanks to WeConnectU for inviting me. And then just a huge shout out to FIFA for making the Bafana game so early this morning that I couldn't watch
Amazing. I
it
almost
because I
forgot
wanted
it.
to get my sleep for the webinar today. So obviously we've been, practicing as litigating attorneys for over 26 years, and we were recently involved in this very case that we are presenting on today, where we represented Mr. Else in a High Court matter, and we subsequently took it on appeal to the Supreme Court of Appeal, which for matters other than constitutional work is the highest court in the land. And what does that mean, John? It means when the Supreme Court of Appeal makes a ruling, that becomes law. So Else versus Venter is now the law in South Africa. And the law in South Africa, obviously it's up for challenge, and unfortunately it sets a precedent as well, because now suddenly we've got a case which for the first time in South African law has shown how the Consumer Protection Act, which is a bit of a buzzword, has really filtered into the rental housing industry, particularly in this instance in the residential rental industry. So to start off, and there's an abundance of information, and I'm going to try and limit it as much as possible, but the slide notes are going to be made available. I'm also, with WeConnectU's permission, going to provide a summary of notes that I've made because we ran the case. So there's plenty of articles written by top law firms about Else versus Venter, what it means, the implications. But I'm going to give you a summary based on insight that no one else has, because we drafted the court papers. We drafted the heads of argument. In very simple terms, I'm going to try to keep it as simple as possible and as unlegal as possible. Else versus Venter was basically turned the presumption on its head that if you have a tenant, a natural person tenant, who signs a fixed term lease for a year or 2 years, in that instance, you automatically would assume, well, the Consumer Protection Act applies because a natural person tenant is a consumer. And if a natural tenant is a consumer, they must get a CPA lease. If you go back to the first slide, just to touch on that, that was the assumption. And normally you would present a lease to the tenant, and that means the tenant would have all the rights available to him, for example. And obviously there might be a bit of duplication throughout the notes, but the industry that has been changed now is that the courts will no longer, and the Supreme Court of Appeal made it very clear, they're no longer concerned with who the tenant is. They're concerned with who the landlord is. And that's a major, major shift, because now rental property practitioners who procure a tenant for the purposes of brokering a lease, earning a commission, a procurement commission, a brokerage commission, or managing the property and earning a management fee, can't simply focus on the fact, well, we've got a natural person tenant and they must pay rental and we take our commission, and they've got their rights in terms of the Consumer Protection Act. And what are those rights? Simply put, they can give 20 business days notice at any time to terminate a lease. If the landlord wants to extend the lease or end the lease, they've got to send out a notice not more than 80 business days, not less than 40 business days. There's a reasonable cancellation penalty if a tenant terminates early. You can't force the tenant to remain in the lease if they want out. These are all things that are available in terms of the Consumer Protection Act, particularly Section 14. But Else versus Venter was an incredibly interesting case because in that instance, the court was presented with these engineers called the Venter family, both engineers, and they entered into a lease with my client, Mr. Johan Else, where they said you can stay there. It's a 36-month lease, which in itself was problematic because we would know that any lease that extends beyond 24 months needs to have a demonstrable financial benefit in order to fall within the CPA. You can't just make a lease longer than 24 months. And in this particular instance, the intention was for them to sell the property if they were going to relocate to Australia permanently. And there was a clause in the lease agreement which basically said, and these points are all covered in the bullet points and they're going to be covered in my notes as well. So don't worry if I'm going too fast or if I miss anything. But effectively, the courts said that was not a CPA lease for the very simple reason is that they were not leasing in the ordinary course of their business. It wasn't a rental agreement that I'm going to earn rental income, you're going to stay there, I'm going to market it, I'm going to remarket it once the lease ends, I'm going to continually market it, I'm going to use an estate agent. They simply provided a lease which says, you can stay here, we're intending to sell, and we are going to give you 3 months notice, which you agreed to, and we did, we agreed to it, that if we decide to sell, you must leave. Now, we will all
Marlon, can
know
I ask you, what
that.
is the ordinary course of business just for the layman to understand?
Absolutely. That was the crux of the whole thing. The ordinary course of business is if you are renting out property in the normal day-to-day routine that could be expected of somebody who runs a property portfolio. So if somebody temporarily lets a property to somebody to say, I'm going to Joburg for 3 months, you can stay there. That's not a CPA lease. Or I've inherited a property, I'm a doctor or I'm a lawyer, I'm just going to let it out for a year to ensure that it's somebody there and it's not vacant and can be broken into. And even though there's no definitive list, the Supreme Court of Appeal did provide several things to look at. And where the shift has come in is that, and this is from the first few points, the traditional view is don't look at the tenant, who is a natural person, look at the landlord. And that's why, which I'm also going to provide to our valued listeners, is a list of questions that rental property practitioners need to ask of their landlords before they put a lease in front of a tenant. So basically what the Supreme Court of Appeal says, this isn't about the lease, isn't about the tenant, it's about who is the landlord. If you're a landlord and you've got 10 properties and you run a rental portfolio and you use estate agents and you oversee that and you get your rental income and you declare to the receiver of revenue, the fiscus, SARS, and you make sure that you continually market it, that would make it in the ordinary course of business. And if it's in the ordinary course of business, then the CPA applies. But if it is not in the ordinary course of business, like a temporary relocation, or you inherited a property and there's no definitive list, there's a list of questions you can ask that allows you to work out the answer. But if it is not in the normal course of business, it's not in the day-to-day business of somebody as if that is their job of running a rental portfolio, and it's a difficult question to answer, that means the tenant has no CPA protection. And that's exactly what happened to Mr. Else. Mr. Else says, I agreed. In this case of Else versus Venter, I agreed you could give me 3 months notice. I acknowledged that you were going to sell the property. Absolutely, I was going to leave. And then he came to Marlon Chevalier, and Marlon Chevalier said, no, 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 no. The Consumer Protection Act is very clear. The Consumer Protection Act says the only way that I can have my lease terminated is if I breach the rental materially. In other words, I don't pay my rental. I breach the lease agreement. You give me 20 business days, because those 20 business day letters are which is sent normally in CPA leases. And only if I don't pay my rental can you cancel the lease. Mr. Else never not paid his rental. He was paying his rental after the court even made this ruling. So it wasn't about that. The question was the landlord leasing in the ordinary course of business? If he was, you can't put a clause in that says, I can give you notice. In fact, the only way Mr. Else's lease could be terminated was if he breached the lease and did not remedy the breach. And that is where the essence of this case is, because now rental property practitioners, before they present a lease to a tenant, need to know who their landlord is. If it is in the ordinary course of business, then they need to know, well, right, that's fine. CPA lease, 7 days to pay or we can sue you. 20 business days before we can cancel. 80 to 40 business day letter in order to offer you a renewal. The tenant's right to terminate on 20 business days notice, subject to a reasonable cancellation penalty. Jean, to make it even more clear, if it is not in the ordinary course of business of the landlord, if it's a once-off let, if it's a temporary relocation, if they're moving to Australia and they're keeping the property there for you to stay in Val de Vie estate, where Mr. Els was staying, but we could potentially come back, we could potentially sell it. If that is the case, it's not a CPA lease. If that is the case, there is no ability for a tenant to get out of that lease. Let me repeat that. A tenant cannot give 20 business days notice to get out of a lease agreement if the CPA does not apply. In fact, if Mr. Else had given 20 business days notice to get out of the lease, hypothetically, because he wanted to move, the landlord would have said, no, you must stay and you must pay, or you can leave, but I'm going to sue you for damages, which includes all the rental I could have earned up to the end of the lease, subject to me trying to mitigate my loss and find rental income elsewhere. So the court
Marlon,
basically
there's a
changed the
question in the
shift.
comment. There's two things.
Yes,
One is there's a question in the comment. The first thing is, so essentially you can only get exit a lease by mutual separation and or exiting the lease at the end of the period, essentially. Otherwise, there will
absolutely.
be consequences. And the question in the comments, which I'm assuming you've already sort of positioned in a different way, but what happens in the case where it is managed lease, that where the landlord is presented by an agency in the lease? The onus is still who is the landlord. Am I correct?
Absolutely. The onus is still on the landlord, but the indications would be that it is a Consumer Protection Act lease, because invariably, if you're using an estate agent, that leads to a perception, not definitively, that it is a rental enterprise. So the courts were quite clear, especially the CSA, not to make a definitive list. That's why I created a list which will allow for a landlord to give all this information. So, for example, a rental property practitioner will now put to the landlord, how many properties do you own? Have you rented this property out before? Have you earned rental income before? Are you leasing it for purposes of a rental income or just to pay your bond? And all these kind of questions will then say, right, I, as a rental property practitioner, have done my due diligence. Based on the information presented to me, absolutely, I believe this is definitely a CPA lease or definitely not a CPA lease. And it's important because let me make it even more explicit. And before I touch on that, with regard to mutual cancellation, a landlord and tenant can, of course, of their own volition, choose to terminate the lease at any time if, of course, they agree mutually. And what that basically means is they do an addendum to the lease agreement where they mutually agree to terminate it on certain terms and conditions. I'll pay you this much rental. You won't charge me that. I leave at the end of this month. Or failing that, when the lease comes to an end. But the point I'm trying to make is that in terms of actually, I think I've lost my train of thought now, but in terms of the CPA, is that if I am presented with facts that it is a CPA lease, based on a CPA lease, if I'm going to choose a letter of demand of the WeConnectU platform, my letter of demand is going to give 20 business days to remedy a breach, isn't it? I'm going to have to watch the WeConnectU calendar to determine when to send out that 80 business day letter or 40 business day letter. If it isn't a CPA, I don't have to worry about 80 to 40 business days. I can send a 7-day letter to remedy a breach. I can cancel on day 8. So the actual risk management involved can impact the landlord greatly. A landlord having to wait 20 business days before a lease ends is very different to a landlord waiting 7 calendar days before cancelling a lease. So the time periods, the loss of rental, the obligations, for example, a landlord having to charge a tenant a reasonable cancellation penalty because it was a CPA lease terminated on 20 business days notice is very different to a landlord saying, you breached the lease, I'm terminating your lease and I'm claiming damages. Damages and reasonable cancellation penalties are different. So the very notices that are sent out, the very instructions that are taken from a landlord, the very directions that a rental agent, a rental property practitioner must give to a tenant, to guide the tenant, to give due regard to the tenant, all changes on whether or not the landlord is acting in the ordinary course and scope of the business of a rental enterprise. If I had to look at that landlord and his property, would I, as a normal person, say to myself, oh, well, he's definitely doing a rental enterprise here. He's got 5 properties. He's using an agent who belongs to WeconnectU. He's managing the property. I'm paying the rental agent. That's a rental property portfolio. But the courts were very clear to say that you may have 1 property and be running a rental property enterprise, or you may have 5 properties and not be running a rental enterprise. So what that basically means is there's going to be more and more cases coming about. And I think what I want the rental property practitioners to take away from today is that there's no definitive answer as long as they can show that they have done as much assessment as possible when they onboard a tenant. Have they done the correct questions with the landlord? Have they made a decision which lease is possible? Has the landlord given as much information as possible? So if things blow up, because in Else versus Fenter, that's exactly what happened. Mr. Else was led to believe that it was a CPA lease because he was a natural person. It was a fixed term period, and you can't contract out of the CPA. I mean, if you look at the Consumer Protection Act, Section 51 clearly says you can't put clauses in your lease agreement that seeks to deny a consumer, a tenant, the right of the Consumer Protection Act protection. And that's the whole big thing now, because if it isn't a CPA lease, I mean, I suppose we can move into the next slide. If it isn't a CPA lease, that tenant does not have protection. That tenant has signed a non-CPA lease. So the ordinary course of business is basically saying, in terms of the Consumer Protection Act, if you look at the act in itself, it basically means, are you rendering a service as a rental property practitioner or as a landlord providing the service of accommodation to a rental property for which are you being paid income? That's what it is. The Consumer Protection Act talks about transaction, it talks about supply, it talks about consumer. And it's not anymore, oh, my tenant is a consumer, the Consumer Protection Act applies. It's more about, is this a business of letting? And that has changed the dynamic completely.
Marlon, there's 2 things. The first thing, a lot of people asking in the questions you've already mentioned, but we will make some lists available after the fact with some questions that the people can utilize to make things easier. And then
Sure.
also there's a question on commercial leases. If you can maybe just touch on that.
Absolutely. Commercial leases. This was a case, and I just want to bring it to your attention. It was focused on a residential lease in Valdevie Estate. There was an initial lease, there was a subsequent lease. The subsequent lease was 3 years long. It had a clause that says I can give you 3 months notice at any time if I want to sell. They found a purchaser, they gave 3 months notice. My client agreed. He then came to me and I said to him, don't leave because you're a natural person. It hasn't been tested in our courts. Its assumption is you're a consumer, you have the right to say, no, I may have agreed to leave on 3 months' notice, but the CPA says you can only terminate my lease if I've materially breached it. For example, not paid my rental. I am paying my rental. I've always paid my rental. I've never stopped. With commercial leases, there's no difference because we're not talking about commercial leases per se. If there is a natural person leasing the property, but that commercial landlord is not leasing in the ordinary course of business, then this case will have an equal application. The only difference being, Jean, is that if somebody is leasing a commercial property, one would assume it is in the ordinary course of business because it would be a commercial enterprise. A big commercial building that is leasing a property to a natural person tenant. In that particular instance, this case probably wouldn't have application because you always have to look at who is my landlord. And if it's a landlord who owns a building, one can assume it's a rental enterprise or it's a rental property portfolio or it's been continually rented or it's been marketed by commercial agents to find a tenant. And we also mustn't forget, something which has been missed in everything is that if the lease agreement is being leased to a commercial entity, then of course you may find that the application of the CPA is non-existent. And it's important to mention this, and let me mention it very clearly. If it's a lease agreement between 2 commercial entities, either the Consumer Protection Act will not apply because it doesn't apply between 2 commercial entities, especially if the tenant commercial entity is above 2 million rand in turnover or asset value, or it will apply, or it won't apply, I should say. It will apply except for Section 14. In other words, if it is a commercial landlord and it is a commercial tenant, but the commercial tenant is below the threshold of 2 million rand, in that instance, the Consumer Protection Act will apply, but Section 14 won't. So it gets very interesting, and that's why this case was simply focused on a residential lease. It was focused on the fact that you had landlords who were immigrating, that it was a temporary location for a tenant, pending them relocating or moving back or selling. And the whole issue is, why must the Consumer Protection Act apply to a private agreement if they were not landlords in the traditional sense? And why should a consumer have the right to ignore what he agreed to, namely to leave on 3 months' notice, just because he is a consumer? It is the Consumer Protection Act. We're not denying that. Tenants have rights. But in this particular case, Mr. Else was deprived of all the rights the Consumer Protection Act gave him because the landlord did not fall into the role of running a rental business.
So Marlon, what we'll do is for those of the people that are still confused, in the help section of WeConnectU, we will make an article available that we will curate with Marlon to make it very clear and easy to sort of explain where the CPA will and will not apply, as well as that list. And there were one or two questions again on the recording. Will it be shared after the fact? Yes, we will definitely share the recording after the fact, but we will definitely provide in the knowledge base a help article just explaining very simply in layman's terms what you guys can expect to apply CPA or not CPA. Because what we'll also do is there's a lot of questions in the comments, and then we'll sort of roll them all into that so that it's answered clearly. I see a lot of likes and emojis popping up on the screen, so that seems to be a popular comment. All right, Marlon, I think
I've
you've
made
already.
short notes,
Yes,
yes.
I
Just if
think
I
you've
can just touch on
go for it.
quickly, there was another aspect which was very interesting as well, which has been overlooked. When we went to the High Court said, no, it's not a landlord because it's simply these engineers who are relocating to Australia. They may come back, and therefore we can't classify them as traditional landlords, and therefore the Act doesn't apply. They confirmed that the notice for 3 months to leave was valid. And they also said he must leave by a certain date. And that's where the Supreme Court of Appeal, we succeeded on that particular point, because just because there's a notice period that says you must leave by a certain date doesn't mean that you have to be thrown out or can be thrown out on that date that you have not left. There still has to be a PI application brought. There still has to be an eviction order obtained. In fact, after the Supreme Court of Appeal had ruled, our client was still in the property. He still did not have to leave. We eventually agreed by a mutual cancellation agreement or a mutual agreement for him to leave. They would still have to brought a formal PI application process, even after the Supreme Court of Appeal said he had no right to be there. So that's very, very interesting. And it's important for our purposes because sometimes you've got estate agents who put clauses in lease agreements that say the landlord is looking to sell the property or it's on the market. There's a clause, and that clause, which you probably have seen in your lease agreement, which says if the landlord wants to sell the property or move back in, we can give 2 months' notice. I authored that clause. I authored that clause for the original TPA and lease spec, which I prepared. I authored that clause for a company called PayProp, small company, that I also prepared their lease for. And of course, I used that clause in the WeConnectU lease that I also prepared for WeConnectU. And that clause is interesting because basically, if the Consumer Protection Act does not apply, as it didn't in this instance, I can put a clause in that says I can give you 2 months' notice to leave if I decide to sell. If you don't leave at the end of those 2 months, I can't just throw you out. I've still got to bring an eviction application. But if it was a CPA lease and I was running a rental portfolio and I put that 2 month clause in, that would be challengeable because I would then turn around and say, how can you give me 2 months notice during the lease agreement if you want to sell or you want to move in? The only way you can terminate my lease is if I breach it and I don't remedy the breach on 20 business days notice. Hope that all makes some sort of sense, but my notes will clearly make it as simple as possible.
And Marlon, I think one of the morals of the stories is agencies do not try to pretend like your attorneys. Please get legal help sooner rather than later.
Absolutely. Yeah, I just think it's absolutely important now that what landlords need to, or rental property practitioners need to do, is change their focus and say, right, thank you, Mr. Landlord. Thanks for bringing a property to my attention. I appreciate that you want me to procure a tenant for you. Absolutely. Here's a CPA lease, natural person tenant, fixed term period. Let's do the 20 business day notice if they don't pay. let's send out the 80 to 40 business day letter if we're going to renew, etc., etc. That's not how it is supposed to be done anymore. As of October last year, when the Supreme Court of Appeal made a ruling prospectively, not retrospectively, as of October 26th, what it now means is when that same landlord walks into your office, says, I want you to find me a tenant, I'm going to say, right, Mr. Landlord, I want you to complete this list for me. How many rental properties do you have? Have you used agents before? What's the purpose of renting it out? Did you inherit it? Did you buy it as a sell and execution? Are you looking to earn rental income? Are we going to manage it for you? Are we procuring the tenant? Give me all this information. Once you've got that information, have the landlord sign a declaration that they've given you all this information, because that will then lead the rental property practitioner, maybe with the help of an attorney, to say, right, I'm going to give this natural person tenant a CPA lease or a non-CPA lease. The difference between a CPA lease and a non-CPA lease is going to dictate the entire management portfolio. It's going to dictate the time periods involved in the demands, in the cancellations, in reporting back to the landlord. It's going to deal with risk assessment. Perfect example for risk assessment, which I think might form part of these notes as well, is that when a lease is terminated, a property practitioner's commission ends as well, isn't it? Your mandate for commission to be earned on a management basis, 10% every month, hypothetically, is linked to the length of the lease. If the lease ends, how do you earn a management fee? And this is so important because in a CPA lease, a tenant can terminate a lease at any time on 20 business days notice for any reason whatsoever, subject to a penalty. That penalty may be a small portion of the commission that you are owed, but in essence, it's going to deny you commission that you would have earned for the rest of the lease period. But if it's a non-CPA lease, that tenant can't terminate the lease, which means your mandate has got longevity. Your mandate will survive because a tenant can't just terminate a lease. And you want to be able to earn monthly commission every single month as long as the lease is in place. So the very management, the very opportunity cost aspect, the economy of earning management fee for a management portfolio is directly impacted on whether the landlord is acting in the ordinary course of business or not.
So I think a lot of people feel that this might be challenging, but I think once we release the lists of and the notes, people will realize that this is actually going to be potentially a benefit to the agencies, not a
Absolutely.
burden.
Yeah, and I don't want these notes, I don't want this terminology. As you can imagine, this case lived in my head. And as I say, if you go onto the internet and you type in Else versus Fenter, there's some lovely articles written by the biggest firms in the country, Worksmans, ENS, some lovely big law firms who have written these articles who maybe might explain it a bit better to me. But the reason why I wanted to do this webinar is because we ran this case and we were at the cold front when we argued before the highest court of the land in making law, which are not constitutional matters. And we were shocked by the ruling, but in retrospect, looking at it, it's about a landlord having the ability to run a property and earn rental income and have an expectation of earning rental income. The problem for rental property practitioners is I can't give you a definitive list. If you tick all these boxes, it's definitely a CPA list. But what I am going to be able to do is basically mitigate your exposure. Because let's assume you complete this list, you have all these details in front of you, and you present the tenant a CPA lease. And it later transpires that it wasn't really a CPA lease. The landlord had one property, but it wasn't marketed in the ordinary course of business. And the landlord turns around and says to you, Mr. Agent, why did you give him 20 business days to pay? Why are you letting him give 20 business days to get out of the lease agreement? I need the lease. I need the rental income. You can at least turn around and say to the property practitioner or to the landlord, listen here, this is the case of Else versus Fenter. This is a list that we gave you. Your answers gave us the belief, rightly so, to give that type of lease to this tenant. Obviously, if your tenant is a commercial entity, you don't have to worry about that per se. But if it is a natural person tenant, you can't just simply focus now on the fact that, well, Consumer Protection Act. I always say err on the side of caution, but you now have to say, who's my landlord? So stop assuming, start assessing. If I'm looking at my notes, look at the mandate procedures. When you sign a mandate with a landlord, do you have a checklist in your mandate which they need to sign where they declare? Because we all know that oftentimes you have declarations by tenants. I am a commercial entity, but I'm above 2 million or I'm below 2 million. Now you've got to have a similar list for a landlord saying, I don't rent out properties all the time. I'm doing it for the first time. I just want to earn a bit of money to cover my bond, etc., etc. So lease templates will need to be updated with checklists. Mandates will need to be updated with checklists. You've got to do your due diligence before you put that lease in front of the tenant, and you've got to have a workflow process. So you know, aha, the tenant hasn't paid on time. Aha, non-CPA lease. 7 days to pay, otherwise we can sue you, or we can cancel your lease. Wait, it's a CPA lease. 7 calendar days, or we can sue you, but 20 business days before we can cancel. And that's where it will start working. It would be so much easier if it was just a natural person. CPA applies, and you can manage your portfolio 20 business days, 20 business days, 20 business days. And that is where you're going to have to be a bit haphazard and have a streamline CPA leases, non-CPA leases. Just for our benefit, John, what I actually did prepare a while ago is a multi-purpose lease, which I've been selling, which basically covers CPA, non-CPA, and CPA excluding Section 14. I've also created a checklist that, of course, which I'm happy to share at no cost to anyone who has joined us for the webinar, a sort of quasi checklist that they can ask all those questions. There may be further questions to ask based on the types of portfolios. But as I say, it's a work in progress. And just bear in mind, and I want people just to remember this if they think I'm being highfalutin here, is that this case of Ols versus Venter was the first time the Consumer Protection Act was actually considered in its application to lease agreements. So it's taken these many years since the Consumer Protection Act came out to come to a court for a ruling to be made which has application. So it's a process we're learning. You're not meant to know offhand, but by doing this webinar and following the notes and appreciating what the veracity of the case is, and the information I've imparted today, I would hope that you've got a bit more of an understanding that it's no longer, oh, well, who's my tenant? It's now, who's my landlord? What does he do for a living? And am I presenting this type of lease or that type of lease? And how am I going to manage it? How am I going to manage expectations? How am I going to manage landlord's expectations? Because don't forget, even though the landlord is your client and the landlord is your principal, the tenant is allowed to have his say and to vocalize what's wrong. And it's a duty to give due regard to your tenant, because after all, that tenant is paying rental. And after all, are we not deducting our commission from the rental that comes in every single month?
Marlon, a few questions on where we can find the documents. The checklists we already mentioned, we'll make those
Yeah.
available. The multi-use lease and a mandate template has even been asked quite a few times in the comments. Can they visit your website? How do they
If
get their
they
hands on
if they
that?
just email me, what I've done is I've got a procurement and management mandate, and what I've done is I've adjusted that mandate to cater for the questions that need to be asked of the landlord. And then for the multi-purpose lease, I've inserted the various clauses as well to cater for the fact, are you a landlord or are you not a landlord? So everything that the case of Els versus Venter has done has been incorporated into my lease that I've drafted, into the mandate I've drafted, and that comes, of course, with a Section 67 mandatory disclosure, which hasn't changed, of course, and it also comes with a checklist that can be presented for the landlord to sign. So I've got all that, I've prepared that, I've been setting that for a couple of months now, and it's a continual change. So if there are any amendments to be made to that, that doesn't come at a charge. But the initial lease it's not a lot of money. I'll provide the costs for them to look at. And as I say, our listeners are more than welcome to go back to their attorneys, their conveyancers, although I think rental property attorneys would be better acclimatized to this type of law. The only reason I've been working on preparing these agreements is because we actually argued this case. So any other attorney other than me would have a knowledge of this case, but I'd like to think we have a bit more of an innate knowledge because we know the arguments that were put to the Supreme Court of Appeal. You can read the judgment and see what they said, but we know what went into the argument. So we've drafted it slightly differently with an understanding that maybe goes a bit further than the judgment. Because if you read any articles in the judgment, you'll see they differ slightly. And I'd like to think that we have an innate knowledge, if you don't mind me saying, of the implications of this
Understand.
case because we argued it.
And then just for listeners, there's the after the event, there will be a post-event email. I know you guys have a lot of emails already, but there will be a post-event email. Marlon's contact details will be in that email, so he will be setting it. That's what's also been put in the comment section. So Marlon, I said in the beginning of the webinar, he's a superhuman. He gets to stuff in record time, but please do give him a little bit of grace. This will be a lot of a wave of information. But yes, he will be giving you guys whatever he can. And again, we will make notice available in the help section of WeConnectU in due course. Marlon, any closing comments?
I think, yeah, because if you don't mind me saying, you know, rental property practitioners were never meant to be lawyers, and it's my old joke. I said if the Property Practitioners Regulatory Authority wanted rental property practitioners to be lawyers, they would have included an LLB in their CPD. I've been practicing rental property law for 26 years. I still learn. I give webinars, national webinars, on a retainer basis to various groups. I offer training as well. It's more bespoke training now because we run a busy practice. So I don't go out and train rental property practitioners. But more importantly, what people don't realize, I actually have a WhatsApp channel. I've got about 1,700 people who belong to my WhatsApp channel. There'll be my phone number on that email. If they just WhatsApp me, I'll send them the link to join my channel. In that channel, I'll put my Cape Talk podcasts. Whenever I'm on Eyewitness News, I share that link. Whenever I've got interesting questions, I put to them. I've also got the Rental Retainer Club, which you would have seen from the logo on the front, where for 600 Rand plus VAT a month, you get 2 hours of my time. I've spoken for 50 minutes today, 45 minutes, and you can imagine what I can do in 2 hours. There you get advice on tap for any rental related questions in email format or word format, voice message. You get a newsletter every month with questions and answers from your colleagues. So you get an idea of what's really happening on ground level. So there are many things. I've got the Rental Retainer Club. I've got my WhatsApp channel, which is free. As a courtesy to WeConnectU, I'm going to provide a checklist anyway. That's for free. And my summary of my notes, which will make it even more simple to understand. But if people want to see my lease agreement, people want to see my mandate, I'll give them a palatable price on, as a thank you to joining in today. And hopefully with all of that, you'll get an understanding. And if there's anything more you want to know, any detailed questions, we can always consider a brief answer. Or of course, if you join the Rental Retainer Club, which currently has about 350 agencies, go to my Rental Retainer Club website address. You might even find one of your branches in that club. So yeah, I've always made it about protecting rental property practitioners. And I think now, because of this case of Else versus Venter, they're going to need a little bit more protection, and hopefully from somebody who knows what they're doing. So if you've got a rental property lawyer on call, fantastic. If you want to have me on call monthly for 2 hours a month, you can join my club and you'll get the best of me 24/7, 365.